The broadcast is now starting. All attendees are in listen-only mode.
So we'll just wait a few more seconds. We're still having a little technical problem. So as soon as everybody has arrived, we will start and I can pass you over to Adrian. So we'll be speaking to you in a moment. Right, so morning everybody, welcome to our webinar. I think we'll start now. So my name is Julie, I work for UnLtd's volunteer and pro bono team, supporting our award winners in the North and the Midlands. The volunteer and pro bono team provide extra support to our award winners in addition to the financial awards and our manager award support. Support includes access to mentors, networking opportunities, masterclasses, and of course our webinar programme. Our webinar programme is open to everyone, not just our award winners. We also have lots of other resources on our website which is available to everyone too, so it's worth checking out our website. So I'm pleased everybody's now online. Just some general housekeeping for today's webinar. Our webinar will last about 45 minutes with 15 minutes for questions at the end. So if you can post your questions for Adrian through his presentation. I'd now like to welcome Adrian Ashton, today's guest speaker. Adrian is a great supporter and friend of UnLtd and our award winners. Adrian is a recognised, approved and accredited provider of advice, consultancy, training and research to various social enterprises, charities, sector bodies and other organisations. He works across various fields and is a published commentator on policy and sector issues. Adrian is also a nationally reputed authority on social enterprise legal structures and governance. So today's webinar is essential for anyone thinking about setting up a social venture and thinking of the legal structure which is fit for purpose now and for the future. So thank you all for joining us today, and I'd now like to hand you over to Adrian.
And as if by the magic of the internet, we swap seats. Hello, everyone. Welcome. So, yes, slight hiccups this morning with some of the technology. So apologies for that. A bit old school in some ways, you know, one computer, one desk, one camera, one mic, one chair, two people. But not to worry, I'm sure we'll get through this. So as Julie says, this is a webinar. This is about legal structures for social enterprise. It might be useful to kind of clarify what this isn't though. What this isn't will be the answer to all of your technical questions about all of the options. What this isn't will be the definitive answer to what you should be or what you need to change into. What this is meant to be is an introduction, an overview of some of the questions to be asking, dispelling some of the myth and hype and confusion that surrounds this part of the world of social enterprise. Because in the time we've got, we can't really go through everything in the detail that would need us to do. also with the number of people who are here. So hello, all the lovely people out there. I think we're about 100 people who registered or connected for this webinar, which is a record. So thank you very much for being part of the new Unlimited record for webinars. This is being recorded, so if you have to nip out halfway through, it will go out online somewhere, probably YouTube in the next few weeks. You can catch up there. And I'm also conscious that a number of you are not just huddled around your computers in a darkened room somewhere, like Julie and I are. You're actually doing this as a social event. So you've clustered together to share a screen or such like. So hello to you who are doing it that way too. Welcome. And just because it is a bit unusual, so like I said, this is a record for the number of people who are doing an Unlimited webinar. And it's also a bit unusual because we know there are people who are doing this as a social as well. Feel free to tweet your pictures as we go through. That would be fantastic. Just to get a feel for who else is engaging with this and what everyone else looks like. So on the screen, you've got the Unlimited, hopefully got the Unlimited tag at Unlimited. There's also me, Adrian Ashton 2, or you can do this on Facebook, Unlimited or on Facebook, as am I. But that's enough waffling for now, really. This is what I want to go through in the next hour or so, because as Julie said, we do want to open up for some questions at the end. And we'll see how we manage that with one screen between us. I'm sure we'll be fine. So what I wanted to do in the time that we've got is actually get you wanting to learn more about legal forms and legal structures, and actually understanding why is it important? Why is getting the right form really important to your success? Why should we spend time worrying about it? Why don't we just get on and do stuff? Surely that's the important thing. Within that as well, I also want to briefly touch upon the role of regulators, the regulatory bodies that oversee all these different legal forms. These are really important, and yet very rarely does any support around legal structure consider them in terms of what they expect from you and what they can do to you. That might sort of mean you have to stop and down tools, or even worse. We're going to briefly go over the 16 options. Hopefully not too many of you will have fallen off your chairs or benches at that point when I said there's 16 legal options for a social enterprise can adopt. Within the time we've got, it will be a whistle-stop tour, but it will just be helping you to understand how they differ from each other, the main features of each. But then also, perhaps most importantly and crucially within all this, how you start to make sense of it all. So I want to share with you as well some resources, some tools, some ideas as to how you can actually then start to reflect on this knowledge and how you make sense of it and how you apply it to your circumstances, to your enterprise, to your community too. So that's the aspiration and the aim. Julie's given me an introduction, which is lovely. As I said at the start, this isn't something which will give you the definitive answer. Okay, this is here for guidance, for illustration, to help give you a bit more confidence as you're exploring these themes and these questions as we go through. The stuff there is a bit of background to me, because I have this idea that whoever you're getting support from in your enterprise, and however you're getting it, whether that be direct consultancy, training event, webinar, whatever, you should test it. Because all of my ideas, all of my knowledge, and the way that I share that is biased and prejudiced. Okay, and it's biased and prejudiced because it's based on my experiences, my knowledge, my understanding. And this, as I've laid out here, is a very brief snapshot of some of where I've got that knowledge and understanding, those experiences from, that have brought me to where I am today in terms of my knowledge and views of different legal forms. That's going to be different to yours. So you should always never be afraid to test it, to query it. And if you don't think it's relevant, it's your prerogative to ignore it. You know, it's your venture, not mine. Your name on the door, not mine. You have to feel comfortable and confident in however you're doing this, okay? Because it's you who's answerable. So never be afraid to question whoever's offering that advice. So first up, as we're galloping through, why do we need to give up our lunch times to talk about legal forms? Because they're quite dull and boring and full of legalese and forms we don't understand. And no, sorry. This is why legal forms are important. Okay? Some of the reasons why it's important to spend time talking about them exploring them, thinking about them. It's about our credibility. So different audiences, different stakeholders, different customers have ideas about how a social enterprise should look and feel. So, for example, a few years ago, pretty much all the health commissioners in the NHS were in love with the idea of community interest companies. So they were a very easy way to get your foot in the door and to get that instant recognition. The other stuff, oh, I think I've just lost my camera. I have to be back again. The other stuff that it's useful to be aware of is how your legal form helps you get money. Okay, and this is the SpongeBob SquarePants moment where we go money, 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 Mr. Krabs. For those of you who aren't familiar with SpongeBob, sorry. Different legal forms allow us to do different things with money. Being a charity means we can knock on a few more doors with regards to grant foundations and grant-making trusts. Being a community interest company or a community benefit society means we are eligible to apply for social investment tax relief and social enterprise investment scheme things. So the way our legal form, the one we pick, actually has implications over how we can raise money and the way we do it, because some legal forms are recognised in different ways according to financing that way. I don't really want to go into that into too much detail, though. That's probably another webinar that we've got coming up in terms of the different financing options and some of the technicalities there. We're also thinking about an enterprise, social enterprise. There's a trading element. Marketplaces change over time, communities change over time. We may need to change the way we do things over time. So we need to have some flexibility maybe built into our legal form. So we started off selling blue tack, but we may want to start offering consultancy around highlighter pens in the future. And depending on what legal form we've adopted and how we've set it up, may mean that's fine, we can just go ahead and do it, or may mean actually we need to get a regulator's approval to change our trading activities. Okay, so it's not necessarily that straightforward. Also, protection of risk. You know, if it all goes wrong, where does the count stop? Where does things take the fall? Avoiding mission drift. Again, you know, markets, communities change over time. How do we make sure that we don't subvert ourselves accidentally? How do we make sure we keep that original vision and passion at the heart of everything we do? So this is why legal forms are important, because they touch upon all of those themes and all of those issues in terms of helping us to protect things, but to give us the flexibility that we need as a trading enterprise and a trading entity. So some of the confusion, maybe just to start with, to dispel some of that. Social enterprise is a bit odd because there are different types of social enterprises. We have cooperatives, which many of you may have heard of. Some of you are probably members of different types of cooperatives. Have charities, been around for, well, since the 17th century in terms of modern charities. We have this idea called social business, which is a bit of an odd one. So a social business, actually a private business, privately owned business, but exists to do social good primarily. So it's a bit of the odd one out in terms of social enterprise. Development trusts, some of you will be development trusts. Social enterprises who are place-based and concerned with uplifting an entire community. Social firms, so social enterprises who are there primarily to support people who are furthest from work back into the labour market. So we have all these different types of social enterprise, and that's part of the confusion. These aren't even legal forms yet, by the way. Okay? It's just how we refer to them by the focus that the social enterprise has. But what there is, though, that what they should all share is the common characteristics that define social enterprise. Now, this has been argued about for the last 15 years or so, or 16 years actually, ever since government started talking about social enterprise and putting it into policy documents. What is a social enterprise? How do we recognise it? And I did some research a few years ago about trying to nail this one. And I went to all the national sector bodies, nationally and regionally. How do they define social enterprise? I went through all of a lot of the funding and investment bodies to the sector, their definitions, and I also went through all the research bodies across Europe for their definitions as well. And I did that old trick of wrote them all out in pieces of tracing paper, held them across the window to see where the light shined through and where they all overlapped. And these 3 points at the bottom now is where they all seem to overlap. This is where that everyone seems to be in agreement. It's a social enterprise if it's these 3 things. It's set up to do something good in the world, and it gets there by trading its way there. Doesn't rely on philanthropy. Okay, it trades to achieve social good. Number two, it makes profit. Has to make profit. If it's not for profit, it's for loss. Okay? So, but there's a question about what happens with those profits. And there should be a lock in it somewhere, some restriction that says the majority of those profits are protected back against that social purpose. And the third thing is an asset lock. So the assets are the things that an enterprise comes to own in its favor. So buildings, cars, helicopters, money, intellectual property, all the things it amasses to deliver on its mission. And those things are locked. Okay? So if the business is wound up, if it's dissolved, if it ceases to be, if it becomes an ex-social enterprise that has shuffled the small coil, those assets are protected. They're given back to the community, to another social enterprise to carry on that original mission. Okay? So as long as it's got those three things in it, then we're okay. And this is also where we start to get a bit confusing. So keep those three things in mind, because actually within any of the legal forms that exist, it's possible to articulate and to write in those three defining characteristics. So we have these different forms. Charities, most people will be aware of. Three forms of charity at the moment, which I'm sure you're all aware of: an unincorporated charity, an incorporated charity, also known as a charitable company, and the charitable incorporated organisation. We have companies, limited companies, with or without shares. We have community interest companies, again, with or without shares. We have partnerships, 2 types. We have cooperative societies, 2 types. And we have sole traders. Sole traders, the self-employed, where most social entrepreneurs start out. Because actually, that's probably the most appropriate thing to do in most instances. Just get out, start doing it, test the idea, work out the model, and then find the legal form that best wraps around that. If we start off with the legal form first, it's going to put all kind of constraints and structures in place that maybe won't allow us to flex our idea in the way that we want it to, as we need it to, as we start to go out and change the world and uplift the community and change people's lives. So that's kind of some of the confusion. Now, before we get into some of the detail of those forms, let's talk about the regulators, the people who sit in the big offices in Whitehall. What they're about, what they like, and where they come from, how we keep them happy. So I've grouped them together because I think the regulators do share a lot of overlap here. So first up, Companies House and the FCA, the Financial Conduct Authority, who superseded the role of the FSA, the Financial Services Authority, a couple of years ago. So generally speaking, though, they're broadly the same. Companies House look after companies, the FCA oversee cooperative societies. Bit of legalese, just to warn you, they don't have a prudential role. Now, this isn't about being the man from the Pru who comes down to pick up your contributions every week or every month. This is a legal phrase for saying they can't tell you how to run the business. Okay? If you think you should employ those people, you can employ those people. If you think you should start trading in those areas, you should start trading in those areas. That's fine. They can't tell you how to run the enterprise. The day-to-day running of it, the management, the strategy, all that stuff, it's up to you. Okay? They don't have a say in that, which is great. What they are interested in is paperwork. Boy, do they love their paperwork. They want to make sure all your paperwork is up to date. A part of that, the way that they make sure that happens, is through the mechanism of the annual return. And the annual return, generally speaking, are your accounts, and the annual return, which says these are the directors, the board, this is where we're trading, and we're still trading, and this is broadly what we're still doing. So everything's up to date. Okay, that's pretty much it. Keep your paperwork up to date, keep on top of it all, and they'll pretty much sit back and let you carry on, unless it gets something really nasty happens. Because they can wind you up. Okay, and here's the thing, they do, Companies House and the FCA have the power to dissolve companies. Now, generally speaking, the only time they do this is where the company is in breach of basic compliance. Okay? The number one reason why Companies House will take action against a company is because it hasn't got its paperwork in. And if the paperwork is late, you get fined. And after so long, they get tired of waiting, they get tired of the fine racking up, and they just strike you off. They dissolve the company. So it's really worth keeping on top of that, because if the company's dissolved without you realising it, then you haven't actually got a legal form to trade with. You're trading illegally. It can cause all sorts of problems with suppliers, with funders, with commissioners, with investors. It's always good to check where you're up to with that. And they can also take power against individual directors, so they can blacklist you. So if you have been found with your hand in the till, breaching health and safety law in terms of things like corporate manslaughter, they can blacklist you for up to 7 years from acting as or serving as a director in other companies as well. So just in terms of keeping your paperwork up to date, be mindful of that. The other side of the regulatory landscape is the Community Interest Company Regulator and the Charity Commission. Now these are grouped together, which might seem a bit odd initially, but let's work through and hopefully you'll see. So, charities and KICs. The regulators that oversee both do have a prudential role. Okay? They do have, both of them have the power to tell you how you can and can't trade. So for example, the Charity Commission will say as a charity, you can do primary purpose trading and secondary trading, and there's clear guidance on what qualifies under each, okay, and how far much you can do before you need their permission, or you need to start to change things fundamentally. They also have the power to come in and say, you're going to stop doing that now, we don't think it's appropriate. Lots of clear guidance on the website about that. KIC regulator has the same power. The KIC regulator can impose restrictions on your trading activities. The challenge is we don't know the guidance for that, because they don't have any published guidance on that particular aspect of their regulatory powers. So it's not only about trading, it's about governance as well, in terms of who sits on your board. There's a recent instance this week, the Charity Commission's reported having appointed a whole new board of trustees in a charity because it's gotten such a mess. KIC regulator has the same power. It can remove and appoint directors as it sees fit. But again, as before, the Charity Commission has clear published guidance and case studies on the basis on which they'll do that. The KIC regulator, no real published guidance yet, so it's a bit murkier. We can only assume that it would be comparable. The board gets really out of hand. People start doing very nasty, naughty things, and that's when they step in. As with Companies House and the FCA, keep your paperwork up to date. As before, that's all fine. The other thing that's useful to be the other thing to be mindful of as regulators in terms of their reserved powers that they can do to you is something like the KIC regulator. And some of you will have already skimmed down to the bottom of this page and gone, ooh, that's a bit unusual. No one told us about that. The KIC regulator is the only one out of all 4 regulatory bodies who has the power to sue other people in your name, if I think it's appropriate, in terms of protecting the assets of the KIC or protecting its mission. Seems a bit extreme. I don't know of any instances where they've used that power, but there's no published guidance on it. Now, some people are already kind of going, ooh, crikey, why would we become a KIC if the regulator can do all these things to us, if it seems so scary? Well, it's actually quite a useful marketing tool and a branding tool, because for some KICs that I know, on the strength of the regulator's powers alone, they've been able to build very strong, robust relationships with commissioners and other organisations by saying, look, if we start to step out of line, the regulator is going to come along and do these things to us to make sure we don't step out of line. And that's a real sense of assurance and reassurance to those different partner organisations that they're trying to work with. So regulators can be useful in that respect as well. So the options then, let's kind of start to skim through some of these. There are 6 types of company. Company limited by guarantee, which is the most commonplace one. Companies limited by share and public limited companies. And then the community interest companies double up on all those as well. Because a community interest company is an overlay, is an add-on to an existing company form. So you must be a company limited by guarantee or a community interest company limited by guarantee. Okay? And then you're beholden to 2 regulators, Companies House and the KIC regulator. So 6 types of companies go with it. Charities we've talked about. You can be an unincorporated charity, so registered as a charity with the Charity Commission, but that doesn't limit your personal risk. If something goes wrong, the trustees become personally liable, which is why we see, over the last few years, we've seen a lot of charitable companies or incorporated charities springing up. This is where we have a company that applies to become a charity. They occupy the same space and time as each other, charity and a company, charitable company, incorporated charity, all the benefits of being a charity, and all the benefits of limited liability on the part of a company. So companies are limited companies. They limit the personal risk of the board and the members. So that's why they do it. But as an incorporated charitable company, 2 regulators to go through, Charity Commission and Companies House. They want that paperwork in different ways. So we've recently seen the introduction of the CIO, the Charitable Incorporated Organisation. The idea of this, it's all the benefits of being a charity and all the benefits of being a limited company, but you only have to go through the Charity Commission. 1 regulator, 1 annual return. It's a very appealing option for many. Partnerships, not that commonplace really amongst social enterprises, but can be quite useful if we're looking at joint ventures, so partnership vehicles working together. Trusts, not really going to talk about trusts because they can't trade, and therefore as an enterprise, social enterprise, not really relevant. Sole traders, touched upon these already, very commonplace, very useful, very flexible for an entrepreneur getting out and going. And being an incorporated association. So very often small community groups will set out and they'll say, okay, you know, we formed ourselves as a community association, as a community group. We've got a constitution, a couple of sheets of paper from the CBS, which gave us some purposes and some rules that we govern our behaviour with each other. And that's it. But it's unincorporated. It's not registered or regulated by any of those 4 regulatory bodies. And as such, there's no protection of liability or risk on the part of individual members or board members. But they can be used for a starting point. And the cooperative societies. So we have what's called a cooperative society. So typically worker cooperatives, people who own and run the business between themselves, and a community benefit cooperative society as well, or a society for the benefit of the community, or BenComs, they're called various things like that. So this is where we see a whole community has come together, said we're going to form a cooperative to save the pub, to set up the village shop, to set up a community energy scheme, to save the local football club. Okay, and that's important because what they've said through that is that allows us to do things like community share issues very easily, to do things about tax reliefs on investment and money that we raise, to do things like protect democracy and to make sure that the whole of the wider community is perpetually engaged and involved, and this thing remains accountable to the wider community going forward in the future. Okay, so that's the quick overview. So a few more minutes on each one in turn, just to kind of give a bit of a showcase to each of them so they don't feel left out. Companies. As far as social enterprise land goes, they are the most common legal form adopted, and in particular companies limited by guarantee. So traditionally, most companies, if you go to an accountant or other businesses and go, we're a company, they will assume you mean a company limited by shares. And in a company limited by shares, whoever owns the shares owns the company, shareholders have voting rights, and shareholders get to take the money out of the company at the end of the year. Now, within social enterprise, those values, those definitions, doesn't really seem to sit that well or comfortably. Because how do we then protect the profits? How do we protect the assets? So what most social enterprises do using a company form is they adopt and incorporate as a company limited by guarantee. Okay? So the members, the people who form the company and who elect the board, say, we will guarantee any debts. And within the rules, we'll specify what the maximum is. And most people say we'll guarantee any debts to a maximum of £1. So if it all goes pear-shaped, we'll never have to pay up more than £1 towards the debts. Okay, pretty straightforward. A lot of flexibility within Companies Act and company law to allow for particular values, aspirations, governance models and arrangements to be written into those rules. Lots of cooperatives who aren't looking at the community cooperative model, but maybe worker cooperatives, cooperative consortiums are using company forms because we can put cooperative values and principles into company articles very easily. And it's pretty straightforward as well in terms of setting them up. We can go through an online agent, we can download the paper forms, we can go to a high street agent, a high street solicitor, or such like, and we do it all that way. It's a few forms, filing fee, bish bash bosh, company's there. And then it just needs looking after. So once a year, the annual return and accounts. Community interest companies, the follow-on to this, because a community interest company is a layer over the top or a bolt onto an existing company. You can't be a community interest company with that being some type of company within that. Company limited by guarantee, which most are, companies limited by shares, or a public limited company. There aren't any PLC kicks out there, but the legislation does allow for it. The idea behind community interest companies, who are 10 years old this year, by the way, it's about a brand, a clear identifier in the marketplace. So as a kick, the law says you must, in your trading name, include the words community interest company or CIC, and therefore everyone knows you're a kick. You're a social enterprise. You're legit. You're on the level. Brilliant. Research from the Kick Regulator and others, though, show that that brand awareness isn't maybe as widespread as it's hoped it would be. And there is a lot of additional legislation that comes with it in terms of reporting, in terms of accountability. There's also a little quirk within Kicks that says they're the only legal form that can't do full electronic filing. Most of your returns and company administration still have to be paper-based. So if you're using an accountant to support you with that kind of stuff, just make sure they're aware of that so you don't get in trouble for late penalty filings. Charities, they've been around for quite a while now, quite paternalistic in nature. Okay, they're based on a philanthropic model of doing good things for other people and to other people. Okay, so that doesn't necessarily always fit neatly within the aspiration and the context of a social enterprise, which is about being in the marketplace, being dynamic, trading, responsive. And that paternalistic culture is also reflected in charity legislation, because the trustees of a charity, in theory, should have no material interest in the charity itself. And a material interest means getting paid, means being a primary beneficiary of what it does. There are ways to manage that tension, but in the main, it means that you have a bunch of people on the board. Most charity trustees don't have any direct involvement in what the charity does day to day, or its services or activities, in the way that a company or a community interest company could, which makes the charity form not always that appealing for many social entrepreneurs. Although they've been around for a few centuries now, so there is that brand recognition. Charities are sort of seen and trusted, more so than banks, politicians, and such like, according to all the surveys. They can trade, as we picked up before. If we look at the stats, most of the bigger charities trade most of their income. Clear guidance on that, that's fine. But it's not always as straightforward a process as it would be for a company to form. Okay, so a company forms by filling out the forms and sending it in. A community interest company fills out forms and makes an application. This is the community we're going to benefit. This is the area that we're going to be based in. And these are the things we're going to be doing, our main trading activities. And the regulator says, yeah, that seems okay. Same with the charity. The charity says, well, we need to have the bank account there. We need to have some money in place. We need to make a clear argument as to what we're doing is charitable, and our activities clearly relate to that, and we can clearly articulate and evidence we're going to create public benefit as well. So a few more hurdles to jump through in that registration. Partnerships, I've mentioned. Partnerships are where two or more people, individuals or corporate bodies, come together to do more than they could by themselves. So quite flexible. In the main, most partnerships are registered with HMRC, the tax office, as do all other legal forms when they incorporate. If it makes money and profit, it can share that profit between the partners equitably, and as a result, it may bring it below certain tax thresholds in terms of the amount of tax that gets paid on it. Most partnerships, though, traditionally, are quite risky. So in a partnership, each partner is responsible for the other's actions. So if we formed a partnership and I ran off with all the money before I paid the bills, then the remaining partners would still be responsible for paying the bills, even though I'd done the run-up. Okay, so it can be a bit risky. You can get into trouble with that. But there's a new form recently been introduced called a limited liability partnership, an LLP. And the idea of that is it allows partnerships to kind of become semi-limited risk. So you register with HMRC, you register with Companies House, you do an annual return that way, and if one of the partners goes bad, the others have a degree of protection from being sued by other people. Don't really talk about this too much in social enterprise land because it only really comes into play where we're talking about joint ventures, collaborations, and mergers, things like that. Cooperatives, though, and I really wouldn't be doing justice to giving you an overview of legal forms for social enterprise if we didn't talk about cooperatives on so many levels. Cooperatives are seen by many, and I would argue rightly so, as the daddy, the mummy, the godfather of all modern social enterprise movements. And we can trace that back. I have historical references that go back to Babylonian agricultural texts on clay tablets that describe what we would recognize as agricultural cooperatives. So they've been around a long time. If we look at them in their kind of context as well, we see a lot of modern social enterprise reflected in them. So the modern cooperative movement, we talk a lot about Rochdale, 1844, the Rochdale pioneers. We look at Rochdale at that time, massive inequality, people being exploited, no real employment opportunities, no state services to support people falling through the safety nets, pretty much everything we see today. So the modern cooperative movement was formed as a response to social needs in the 19th century that are still with us today. Key defining characteristic of democracy is this idea about saying it's about being accountable, self-help, self-responsibility. It's not about handouts, it's not about charity. Democracy is a key way that we reflect that and we build it in. It should be a key element of whichever model it's adopted with. And although I've kind of touched upon the fact that cooperatives can be structured within company law now because it's flexible enough, many still use the cooperative society form, what used to be called industrial and provident society legislation and is now cooperative society forms. And it's an interesting parallel there because in the middle of the 19th century, these early cooperative societies were saying, government, we don't have a legal form that allows us to properly reflect and protect our values and our purposes. And government formed industrial and provident society legislation. And then about 10 years ago, the wider social enterprise was saying, government, we don't have a legal form that allows us to properly reflect and protect what we want to do. And so government formed the community interest company legislation. So there's a lot of parallel there, a lot of kind of stuff in modern social enterprise legal forms and practices that have come out of the cooperative movement. And that's why a lot of social enterprises are still kind of saying, actually, yeah, we like this model. It's a good legal form as well, particularly around community share issues and such like. Okay, so how do we start to make sense of all this? 5 minutes to try and wrap this all up to allow us a few minutes for questions, which is where Julie and I will then start to kind of lean in and out of the camera shots as we go along. Okay, how do we start to make sense? So 16 options, 4 regulators. How do we start with all this? Okay, what I would suggest is don't start by looking at the list of options. Right? Start with your model. Start with your enterprise model. How is this going to work? I would then say, or suggest, you look at this idea called cramp. And this is something I've been one of only 3 original ideas I claim to have had in my life so far that I'm aware of. And I've been working on this for about 12 years now. This is about a framework for thinking about your governance, your financing, your business model, and how all of that can then relate to a legal form, to wrap it all in. So just running through this list, and what I suggest is if you know exactly what your responses are to these 5 headings, then it's really easy then to look against all those legal forms and go, yes, that's appropriate because we can do that in that form. No, we can't do that in that form that way. So we'll discount that off. And the 5 are credibility. Who do we need to win over? Who do we need to impress? Relationships. Who do we need to get on with internally and externally? And how should those relationships be structured and managed and governed and overseen? Accountability. To whom do we want to be answerable to? And on what terms? Okay? Do we want to just become saying, well, actually, we want to be quite responsive to the marketplace rather than a community? So in which case, actually, having a wider membership in the cooperative model, cooperative society model may not be appropriate. Give us that responsiveness we might want because we're kind of going all over the countryside. So a company form, maybe a community interest company could be useful. Because on that basis, we've got a regulator who is overseeing us, who does have a big stick, who gives that reassurance to others. M is for money. Where's the money going to come from to start us up? Where does it come from in the future? How do we feel about money? Do we want to borrow it? What's different ways of doing that? And finally, the mad scientist moment, power, decision making. Who holds power? Who makes decisions? On what basis do they get that power? How are they held in check? Okay? You work through those 5 themes, discuss it amongst yourselves with a mirror if it's just you, and then you start to look at those legal options and those different forms. And then it starts to become clear what's appropriate and what isn't. And I think it's really important to actually work out what isn't right for us, because to know why, because then when we're talking with other people, with funders, investors, partner organizations, we start to say, okay, this isn't right for us, but we know why. So if a commissioner says, oh, if only you'd been a community interest company, we would have commissioned you. You can turn around with confidence and say, it's not right for us because it wouldn't have allowed us to work out this part of our business model. However, the model we have adopted still allows us to do these things in this way instead. Keeps you in control, keeps you in charge of your business. Another way of looking at this question of making sense of it all is, well, what have other people done? How have other people worked this out? What are other people doing? Okay, and we're thankful to Social Enterprise UK here, because every 2 years they do a map of social enterprise land in the UK. So we're due for publication in September for the next one. But what this starts to do is it starts to lay out what are the legal forms, what ways a social enterprise is incorporated in the UK, and also over time. So in the main, it's still companies limited by guarantee, because they're quick and easy to set up, they're very flexible, they're also quite responsive and easy to change into other things in the future as well as we go through. Down the bottom of that list, as we go down, companies limited by shares, not that commonplace, but I think they're going to be, we'll see them start coming up soon, and cooperative societies. There's been a huge spike of interest in using cooperative societies to use community share issues with, and also various tax relief schemes that the government have introduced recently. So I think we'll see those also performing strongly again in terms of as a popular choice as we go through. So it can be interesting to say, well, how have other people done it? And don't be afraid to talk to others. NCVO, National Council of Voluntary Organisations, also do a map and an almanac every couple of years. Recently they kind of put one out, and this is the latest figures that they've been collating and putting out in terms of a bit more beautifully perhaps in terms of design. How are people starting to work out their legal form? So what types of organisations are there? How many are using this form? And what kind of percentage figure is that as well? So you can start to see how they start to compare and contrast against each other. So that's quite a useful one, and that's online as well, as all the other stuff is. There is also a very nice website called getlegal.org.uk. This is quite a fun one. You go onto it, register with your email address, and it will ask you about a dozen multiple choice questions. Okay? And it'll be a range of questions that cover pretty much all the scenarios from startup to growth to the enterprise kind of maturing and ultimately being wound up. And it's scenario based, and it gives you options, and you answer, well, in that situation we think we'd want to do this or be able to do that. And then at the end it spits out, say, on the basis of how you've answered, these are the legal forms that will allow you to best do it that way in the future. So it helps you work through some scenario-based stuff that way. So just to go back briefly, as a word of caution on that, every time you do it, it will probably spit out a slightly different answer. Because as with all questionnaires and forms and surveys we do, it's massively affected by how sunny it is outside, if we just had lunch, who we're doing it with, what time of day it is. But it's a useful way to start to make sense of how your choice of legal structure impacts upon the way that you manage and run the enterprise going forward. And then the last bit of signposting to offer you as well, to flag up, I think it's a really good one, is this publication called Simply Legal. Okay, it's available as a free PDF from the Cooperatives UK website, and it came out of a national programme under that banner of Making Local Food Work a couple of years ago. I think at the moment it is the most comprehensive and plain English guide to all of the different legal options. It lays it out, quick summary overview of each, features, how you use it, summary of pros and cons, and some case studies, and some tools to start to work through in terms of flow charts and yes-no questions. Okay? There are other guides out there. I think this is probably the good overview. Okay, so once you've started to work through, we think we'd want a form that could allow us to do this, we're concerned about that, then start dipping into this, because that's a good way then to start to test it and to build your knowledge and understanding. Because ultimately, whatever legal form you adopt, you're going to have to answer for it, not only to the regulatory body, but to all the other organisations you work with in the future. So you need to understand why this is the best thing for you. And this leads me to my closing comment, really. So if any of you have zoned out, dropped off, nodded off, had to nip out for a phone call and you've come back for this, this is probably the most important thing of the last kind of 45 minutes to remember. Never pick your legal form because someone else said that's what you should be. Because that someone else is not signing up on the form with you. That someone else is not running the enterprise with you. You're responsible for it. You're accountable for it. You are answerable for it. You need to be sure it's the right form for you and it's going to allow you to work this enterprise out and to take it forward in the way that you feel is most appropriate. Okay, so don't feel you should be swayed because someone in a shiny suit or them over there did it that way, or the sector body or funder says we should do it that way. Always question it yourself. Okay, you're going to be responsible for it. Social enterprise the legal forms you adopt for social enterprises can make or break a business. Okay, I've seen some enterprises rip themselves apart and not succeed and fail massively because they had the wrong legal form. It constrained them so much in terms of what they needed to do. It didn't open the doors they hoped it would because they didn't take the time to ask these sorts of questions. How will it help me do this? What other options are there? Okay, so that takes us through the forms that we had there. That's the end of my slideshow. This means we can now come back to Julie. So I will swap seats briefly. Julie can then have a quick look at questions and we'll see what goes from there. Once we scroll up the pages. Don't worry, folks. You get to see all the clever stuff behind the technology as we go here.
Right, thanks very much everybody, and thanks to Adrian. Thanks for demystifying such a complex issue and giving so many tools to support with your chosen legal structure and all the signposting. So we have the first question. Oh, will there be a recording available afterwards? Yes, all our webinars go on our UnLtd YouTube channel. So thanks Remy, that will be available over the forthcoming days. We've also been asked, were there any slides? So I don't know if we have a further technical problem there, but yes, there will be slides and we can email those to you and at a later date. So first question from Tim, does the KIC regulator plan to publish guidelines?
Okay, so hello Tim. Okay, so yes, in terms of that technical question about the slides, I've just had a quick skim through on Twitter, so thank you for those of you who have been sharing the images that you took of yourselves with the forms. And Dalek Bob, fantastic, remember the Dalek. If you're not quite sure what that's about, go and look on Twitter. So Dalek for joining in the webinar, which is quite exciting. Yes, apparently it seems that as we went through, there was a bit of a glitch with some of the software and all you got to see was my face. There were a set of slides that went with it. What we can do is UnLtd have a copy of these slides. We can maybe try and get them emailed out to everyone afterwards. What I can do as well is I'll put them up onto SlideShare, so you can pull them up that way as well. And again, once I've got those up, we'll send the link out too as well. So does the KIC regulator plan to publish guidelines? Tim, I don't know, I'm afraid, is the short answer to that. The KIC regulator has guidelines, but they're quite broad at the moment and a bit ambiguous. What they don't have and they don't publish, which the other regulators do at the moment, are case studies that say these are the particular companies or charities or societies that we've investigated and the grounds for that investigation and the action that we took afterwards. So because we don't know any of that happens at the moment, we're all a bit in the dark. Now, what we also know, though, is that the regulator is about to change again. So the KIC regulator is about to, Sarah Burgess, who's the current head regulator, is moving on soon, which many in the sector will be sorry to see her go because we think she's actually done quite a good stand-up job in that post the last couple of years. What we do know is that the KIC regulator role, that function, is going to be merged into another government department as well. So if anything, my suspicion is we'll probably see a little less clarity in terms of guidance from the regulator going forward. But as with all things, I will remain and hope I'm proved wrong on that. But if in doubt, we can contact the regulator. They have an email address. We can ping them questions, and we'll see what goes from there. Alternatively, you can get in touch with the KIC Association. Okay, so http://CICASSOC.ning.com, kicassoc.ning.com. It's a free online group that's been set up by a couple of KICs about 10 years ago as a kind of a self-help group. So KICs from all over the country can come together. We're having an issue with this. Who knows about that? To post and to clarify understandings that way too. Hopefully that covers that. Mr. Lee, I wonder if that's Mr. Chris Lee down in the south of England. If it is, hello, Mr. Chris Lee. Nice to see you from you again. If it's not, hello, Mr. Lee. Can you use the word trust in your company name if you're a company limited by guarantee? Off the top of my head, probably not, because I have a suspicion that that is one of the restricted or sensitive words that Companies Act covers. So there are certain words that you can't use in an incorporated or registered trading name, most of which relate to institutes or inferring royal patronage. However, you can just do a quick check on Companies House, but I have a suspicion that's probably in the list of restricted words, so you'd have to go through some additional kind of compliance and arguments with Companies House to get that agreed. Mr. Lee has another question. When you see a company described as limited by guarantee with charitable status, what form of charity is that? It's a regular charity, registered with the Charity Commission. It's just that it's also registered with Companies House. So it's an incorporated charity. Acts and behaves in the way that any charity would, but it also has the benefit of offering its trustees and members limited liability, so it protects their personal risk. We're doing that. Daryl Chambers, another question. How would you pay yourself as the Chief Executive Officer of this charitable incorporated organisation? Okay, not me on the board. Daryl is the easy answer to that one, I think. CIO is a form of charity. Any charity shouldn't be employing its trustees, or trustees shouldn't be employees. So if you're going to take on that kind of top management role, then you need a group of people on the management level above you that you report to and have oversight as that. But this goes the same way for any legal form, really. If you set it up and it employs you, you have a couple of options. You set up a payroll system, PAYE, regular pay slips, as long as there's money in the bank to pay it, or you set yourself up as a consultant to it. So you work for it part-time, but you're working for other people as well while the enterprise gets up and going. So you're a subcontractor. You generate invoices on the kind of as you go along and work it that way. That's though starting to move into grounds of payroll, employment, and such like, which is a different webinar and different subjects. I don't really want to get into that too much here. I'm also conscious that we're into the last few minutes before people start to disappear off. And Roxana has a question as well. Hello, Roxana. We're looking to create a social enterprise which will include 3 elements: a cafe, a shop, and an event space. I don't think it's necessary. It's not automatically necessary to split all those 3 elements into 3 different legal structures, Roxana. You can probably hold all 3 quite easily within one legal form. You manage them as kind of separate services within the one legal structure. I think maybe there's something there around business modeling that might be useful to spend a bit of time looking at. So the social business model canvas from the Young Foundation is a good template to start to pull out some of those ideas. I think maybe if you just have a poke around social enterprise land, look at social enterprise cafes and such like, social enterprise event spaces, social enterprise pop-ups. There's lots of examples of stuff going on there as well that are taking stuff through. Hopefully that answers that. I have an awful suspicion that, yes, I've now found the button. Now I've got to the end of the webinar that would have shared the slides. So sorry about that, everyone. Maybe next time we do the webinars, you see the slides that way. But again, we'll make them available online afterwards. Okay, last question. I will take this from Seamus Carlin. Seamus from Ireland. Hello, over the sea. In terms of liability, which legal form offers the most effective protection for personal liability for voluntary directors? If it all goes pear-shaped, what's the best legal form to protect non-executive voluntary directors from being sued? The easy answer to that is any which are incorporated. So any which have a company form, limited company, and against that also flow the community interest company forms as well. Any of the cooperative societies that are then governed and overseen by the Financial Conduct Authority. Okay? If it's a charity, either a charitable incorporated organisation or a charitable company, because that's the basics for it there as well. What you may want to do as well, that some organisations do, is to take out a kind of a trustee or a director liability indemnity insurance policy. They're quite expensive, but some people like to take them out as a bit of additional safeguarding. However, if the board have been found to be fraudulent or negligent, then that liability goes out of the window regardless of the legal form. Okay, so if you're fraudulent, which basically means we ran out of money, we knew there was no chance in hell that we were going to get any more ever, but we carried on taking on debt and spending it, you can argue that's fraudulent. You knew something was going wrong, you knew you should have stopped, but you carried on regardless. Okay, so you can be taken for that. Or negligent. So let's say we have a warehouse, somebody fell off a ladder and broke their leg, and then 2 months later, someone else fell off the same ladder and broke their leg, and we've done nothing to check out the safety of the ladder in the meantime. We've taken no actions, even though we knew there could have been a problem. That's negligent, and again, you automatically become personally liable then because you hadn't taken appropriate steps. So hopefully that clarifies that one as well. Thank you for those lovely comments that are coming in on the bottom now. Thank you for your time. As you said, this is one of a series of webinars that UnLtd offer. Slides will become available subsequently. It's been a record-breaking webinar, the numbers of people logging on. So maybe last words to Julie. We'll swap the chairs again.
Thanks. So once again, thanks to Adrian for his expertise and support. I will email everybody the slides out from today's webinar over the next couple of days. And sorry about all the technical glitches we've had today, but thanks for bearing with us and staying with us right till the end. So you will have all that information. So thank you. So just our next webinar is after the summer break on the 11th of September. It's with Melanie Bryan OBE, How to Tender to the Public Sector. So if you'd like to book, please book via our website. And all that remains is to thank Adrian again and thank you all for listening and to wish you all a good afternoon. Thank you. Bye.